My name is John Stepford. I'm the director of the Hamilton Center for Classical and Civic Education here at the University of Florida. We are a new academic unit here devoted to providing a curriculum that will help students develop the knowledge, habits of thought, analytical skills, and the character to be citizens and leaders in a free society. And one of the ways we do that is by putting on events modeling the value of civil discourse. That is the idea that people can have a debate, a real debate, about matters of public importance. They can disagree with each other vehemently and still recognize each other as part of the same community, maybe even be friends with each other. And I think our two speakers today really model that. You're going to get to see a great debate today between two of our country's preeminent scholars of constitutional law. So let me briefly introduce each of them, and then I will let them have the floor. So just going in alphabetical order, Randy Barnett to my immediate left. Randy E. Barnett is the Patrick Hotung Professor of Constitutional Law at the Georgetown University Law Center and is the faculty director of the Georgetown Center for the Constitution. After graduating from Northwestern University and Harvard Law School, he tried many felony cases as a prosecutor in the Cook County State's Attorney's Office in Chicago. A recipient of a Guggenheim Fellowship in Constitutional Studies and the Bradley Prize, Professor Barnett has been a visiting professor at Penn, Northwestern, and at Harvard Law School. Professor Barnett's publications include 12 books, more than 100 articles and reviews, as well as numerous op-eds. His most recent book is The Original Meaning of the 14th Amendment, Its Letter and Spirit, with Professor Evan Bernick. In 2004, Professor Barnett argued the medical marijuana case of Gonzalez v. Raich, or is it Raich? Raich. Gonzalez v. Raich. I've always wondered that, so thank you. Before the U.S. Supreme Court. In 2012, he was one of the lawyers representing the National Federation of Independent Business in its constitutional challenge to the Affordable Care Act in NFIB versus Sebelius. Our second guest, only in alphabetical order, further to my left is Professor Mitchell Berman. Professor Berman is the Leon Meltzer Professor of Law and Professor of Philosophy and co-director of the Institute of Law and Philosophy at the University of Pennsylvania. Mitch Berman writes and teaches in American constitutional law and theory, the philosophy of criminal law, general jurisprudence, and the philosophy of sport. His contributions to these diverse fields include a novel, non-originalist theory of American constitutional interpretation, which I hope we will hear about today, a new positivist account of legal content, and an original retributivist justification for criminal punishment. He also claims to have solved the paradox of blackmail, the mystery of unconstitutional conditions, and the age-old puzzle of whether referees should swallow the whistle in crunch time. So again, during Q&A, we can get to some of those questions. He's the author of numerous articles and book chapters and has published in leading law reviews and philosophy journals. His case book, The Jurisprudence of Sport, Sports and Games as Legal Systems, inaugurates a new field of legal theoretic inquiry and pedagogy, one that introduces students to legal concepts and problematics through the study of rules and practices in sport. So, okay, so I think our first speaker will be Professor Berman. So, Professor Berman.
Thank you all so much for being here. It's a real pleasure to be here. Sound good? It sounds from the introduction like I actually have a choice about whether I should tell you about my theory of constitutional interpretation or something else. John said he was hopeful that I would talk to you about my theory of constitutional interpretation, but seems like he left open that maybe I could talk to you about retributivism or sports. But I will take up that invitation and speak to you about constitutional interpretation. I see here, you don't see here, but the flyer for this event says, how should we interpret the Constitution? How should we interpret the Constitution? And that is a very familiar way of posing the question. It makes it seem like this is an activity. Constitutional interpretation is an activity. It could be done well or poorly. What's the manner in which we should do it? How should we throw a football? That's an activity, and maybe we could get good guidance on how we could do that activity. I think in this case, though, the question is a little bit misleading, perhaps. It may not be the most useful formulation of a question in the relevant space. How should we do this thing? Well, here's a possible answer. We should interpret the Constitution so that we correctly ascertain and announce the law. That's how we should interpret the Constitution. We should interpret the Constitution so that we get the law right. The activity of interpreting the Constitution is perhaps the activity of trying to figure out what our constitutional law is. What are our constitutional rights and duties and powers and permissions and immunities, things like that. So the answer to the question is, how should we interpret the Constitution? Could be, we should interpret it such that our answers about what the constitutional law is are correct. Who thinks that? Well, I think Justice Scalia thought that. I think Justice Scalia's main contribution to debates over the question of how we should interpret the Constitution was to say, you know, that's the way we've been asking the question for a long time. But really, what judges should do, at least, when they're interpreting the Constitution, is figure out what the law is. So the real question we should be asking is, what makes it the case that the law is what it is? Or put another way, if it's the case that we have a constitutional right to X, whatever X is, if we have that constitutional right, what makes it so? If Congress has the constitutional power to do thus and such, what makes that so? In philosophical terms, we might say, in virtue of what do we have the right to X? In virtue of what does Congress have the power to regulate thus and such? I think that was a great insight on Justice Scalia's part. And he had an answer to that question. And many of you are familiar with that answer. His answer, to a pretty good approximation, was what makes it so that we have a right, a constitutional right, when we have a constitutional right, is that that's the original public meaning of the constitutional text. All of our rights just are whatever the original meaning of the constitutional text says are our rights. All of Congress's powers are whatever the original public meaning of the constitutional text says is the power of Congress. When I say the original public meaning, I mean the original meaning at the time of the ratification of any particular text. So, of course, the original public meaning of an amendment to the Constitution is the original public meaning at the time that that amendment was ratified. The original public meaning of the First Amendment would be whatever the meaning of the First Amendment had in 1791. The original public meaning of those parts of Article 1 of the Constitution that say Congress shall have the power to do this and to do that. Well, what are Congress's powers? They're whatever the original meaning was of those provisions in the constitutional text that say Congress has the power to regulate commerce or to create a uniform rule of naturalization or whatever. So I think Justice Scalia would have said that when we ask how should we interpret the Constitution, that really should be pointing our attention to a different question, a slightly different question, which is what determines, in the sense of what makes it so, that our constitutional rights are what they are? What makes it the case that Congress has a power when it does have a power? His answer is just whatever the constitutional text's original meaning was. If the original meaning of some part of the constitutional text was women have a constitutional right to terminate an unwanted pregnancy, then yes, women have a constitutional right to have an abortion. If that's no part of the original public meaning of any part of the constitutional text, well, then they don't. And that's all that needs to be said. That's the story. So how should we interpret the Constitution? We should interpret it by taking out our dictionaries and other sources that give us some good guidance on what the original public meaning of the text was, and then follow whatever our inquiry reveals is the original public meaning of the text. Okay. So I told you that I think that that's the better question, what makes our law what it is, what determines or constitutes our constitutional rights and powers. That's the right question, and I've told you what Scalia's answer was, a very familiar answer, the answer that generally is called originalism, although originalism is a family of views now. Okay. I think that that's the right question, and I think that is the wrong answer. So I think the originalists were onto the right question, and I think, unfortunately, they've supplied us with the wrong answer. Now, in saying that, I want to make clear that I think the answer that Scalia and originalists have provided to their question is a very sensible answer. So if you are sitting there thinking, yeah, that makes sense. What's the law around here? What's the constitutional law? The constitutional law is the meaning of the constitutional text. What else could it be? That seems perfectly intuitive. But lots of intuitive ideas actually prove to be wrong on inspection. So it's intuitive that heavy objects fall faster than light ones. Almost everyone thinks that's so. Aristotle, no dummy, was quite convinced that heavy objects fall faster than light ones. Galileo proved that they don't. So it's a perfectly intuitive idea, but it's false. So the idea that the law, the constitutional law, properly understood, is just the meaning of the text, is also an intuitive idea, but one that could be false. In my remaining time, I'm not going to be able to fully seal the deal, to fully persuade you that it's false, nor am I going to have time in my remarks to fully sketch out the right answer to that question. But I'll try to say enough to both push you off a little bit that intuitive idea, lead you to think that it may be mistaken, and also say enough to give you a sense of a better answer, which is out there in the wild. Why should we be skeptical of the claim that the law is nothing other than the meaning of the text? Well, the main reasons we should be skeptical of that is because we're familiar with lots of legal systems or other rule-governed systems that are, if not legal systems, then adjacent to legal systems. Like the rules of religious ritual and observance in many religions that we're familiar with and that some of us practice. Or the rules of sports. That's why I got interested in sports, because I'm interested in things like, hey, what are the rules around here? And sports are very similar to legal systems. If there are any Europeans here, they would know that the rule books of all European sports are the laws of the game, the laws of football, the laws of rugby, and so on. If you pick up a rule book of an American sport, you will see lots of legal terminology. It shall be illegal to thus and such, okay? So in lots of legal systems we're familiar with, we're quite comfortable with the idea that there are lots of valid legal norms, lots of legal rights and prohibitions and duties and things like that, that are other than the meaning of the text. I'll give you some examples in a moment. But here's some reason why that shouldn't surprise you. Here are a few things that the law could be, if not the meaning of the text. There are some things that seem like possible alternative candidates. Sometimes the meaning of the text departs from what the authors and ratifiers of the text, or let's just say the authors of the text, intended to communicate. Sometimes our language betrays our intentions. And then the question naturally arises, should we follow the ordinary public meaning of the text, or should we follow what the authors intended to communicate when they come apart? Another situation is this, especially in old legal systems. Practices by the participants in the legal system. By that I mean the people who are regulated and also the regulators, the equivalents of the police and the judges. Over a long time, all that practice can depart in sort of an organic way from the meaning of the text. So, for example, where I'm originally from, New York City, I don't know if this is what it's like here in Gainesville, but there's a rule in the books that says something like, "Thou shalt not cross the street when the light is red. It shall be illegal to walk in the street when the light's red, or to cross the street not at a crosswalk." But everybody does it, and the cops see you, and no cop stops you for it, and the practice just becomes, well, that's okay. Some states have laws in the books that say it shall be a crime. It's a crime to engage in fornication. Fornication is premarital sex. But it's not enforced, and over time it has just gone by the wayside. And now if a cop were to find out that someone had engaged in premarital sex and seeks to arrest you, I think a lot of people would have the reaction, that's not the law anymore. Basketball. Anyone a basketball fan here? I don't know how the Gators are doing this year. Hope they're doing well. I don't actually really care. I'm just saying that to be polite. Well, you might know that it is a perfectly, completely accepted part of the practice of basketball to foul someone intentionally in crunch time when there's only a little time left and you're behind. It's called a clock-stopping foul. Now, the rule book says it shall be illegal for any player to push, hold, or impede a player on an opposing team. But we all know it's not illegal. It's perfectly okay to foul someone for the purpose of stopping the clock. They get free throws. How do we know that's perfectly okay? Well, if I were to foul Randy in the last minute of a game, if we're on opposing teams, there are 5 seconds left, and he's up by 2 points. And if the referees didn't call a foul, I would have a valid complaint, because now I have a power to stop the clock by means of fouling someone. It's not thought to be illegal or impermissible. I can do it over and over and over, and no one thinks it's against the rules. In constitutional law, I don't know how many people here are constitutional lawyers or law students, but I know that some of you guys are law students. So you know, just from your study of constitutional law, that there are a whole bunch of doctrines, lots and lots of doctrines, which don't seem to comport, doctrines and holdings that don't comport with the original public meaning of the text. And some of those are controversial, but many are not. So a good one is the 11th Amendment. The 11th Amendment combined with Article 3 of the Constitution. For those of you who are not lawyers, I apologize for this. You can just take my word, or you can look at other people and see whether they're nodding or scowling. The 11th Amendment text says that the judicial power shall not extend to suits brought against the state by citizens of another state. Against the state by citizens of another state, not by citizens of the same state. But our law now is, there's sovereign immunity. States cannot be sued in federal court or in state court, even by citizens of their own state. This is a doctrine, by the way, that's supported by conservatives, not by liberals. That's not a criticism of the doctrine. I mention that only because the people who are supportive of this atextual, anti-textual 11th Amendment rule are people who, by and large, support or give lip service to Scalian, original public meaning, originals. There are lots of things I think that we are committed to as a polity that are not consistent with the original public meaning of the text. Here's one. Most people think that it would be unconstitutional for a state to establish a church. It would be unconstitutional for the governor of Florida and the state legislature to say, from now on, we have an established church. We're going to be Baptists, and we're going to take our tax revenue, we're going to tax y'all, and we're going to take some of that tax revenue to pay the salaries of clergymen from our established church. Almost nobody thinks that is consistent with our constitutional order. But it is entirely permissible given the original meaning of the constitutional text. The First Amendment absolutely allows states to establish churches, and the dominant understanding by historians is that the original meaning of no part of the Reconstruction Amendments and no part of any amendment adopted after the original Constitution in 1789 or the Bill of Rights in 1791, no part of any of those amendments say otherwise. If we were originalists, we would all believe, as Clarence Thomas does to his credit in terms of consistency, that it is perfectly compatible with our Constitution for states to formally establish churches. And yet very few people think that's okay, even on reflection. Another example, I won't give you a ton, but here's one. It is unconstitutional for a state to make it a crime for people to marry across races. That's the holding of a 1968 decision, Supreme Court decision, Loving versus Virginia. Pretty late in our constitutional understanding, states, including the great state of Florida, made it a crime for people of different races to get married. I think most people today think not that Loving versus Virginia was probably wrong, but we should stick with it for reasons of stare decisis. Overwhelmingly, people believe it is a true fact about our constitutional order that it is unconstitutional for a state to make it a crime for consenting adults to marry people of a different race. But if you're an original public meaning originalist, that has to be an open question. Now notice, I am not standing here and insisting to you that there's no possible way to achieve that result if you're an originalist. I think it will require a lot of fancy dancing, frankly. But I'm not here to persuade you that the historians are going to come in here and tell us that the Constitution, the original meaning of the Constitution, doesn't support that verdict. I know that there are some historians who say otherwise. But I don't think most of us think that our confidence in the proposition that the state of Florida cannot make it a crime for a white person and a black person to get married depends upon what the historians of the middle 19th century tell us was the original public meaning of the Privileges or Immunities Clause. Our confidence in the proposition that that is unconstitutional, I think, is not contingent upon some facts about the middle 19th century. Historians tell us that it was part of the original public meaning of the First Amendment that Congress could criminalize blasphemy. Do we think that it is permissible for a state to make it a crime to blaspheme now? I don't think so. Are any of these proofs that should convince you if you think otherwise? No. I'm just trying to mobilize what I hope to be some intuitions among people in the audience. That you have some commitments and some intuitions about what our constitutional order permits or requires. And many of those are not consistent with the original public meaning of the Constitution. Okay. If original public meaning originalism is wrong, then what's right? If it's not the case that our law, properly understood, is fully made out by, fully determined or constituted by the original public meaning of the constitutional text, then what is the story of what our rights are? What makes it the case that we have a right to possess a firearm if we do, or a right to marry someone of the same sex if we do, or the right to terminate an unwanted pregnancy if we do? What makes it different? Well, I have a theory. I call it organic pluralism. And it's a somewhat complicated theory in its details. But in broad strokes, it's pretty simple. And I'll explain it to you in contrast to Scalian originalism. Scalian originalism has, I think, two distinctive features. Fixity and monism. Fixity and monism. I'll take them in reverse order. The monism is what I've already told you. That the law, our constitutional law, is made out by, fully determined by, or is reducible to, the meaning of the text. Well, what about our historical practices if our historical practices have departed from the meaning? No. Our law is fully made out by the meaning of the text. That's the monism part. There's this one thing that gives us our law, the meaning of the text. And fixity is the idea that the thing that gives our law the content it does is fixed at a particular moment in time. I think both of those claims are mistaken. I think at the ground floor, the fundamental level of our legal system is not monism, but pluralism. I think that there are a lot of considerations, factors, that make out what our law is, all operating at what we might call the fundamental level. The meaning of the text is one of the things that matters, constitutionally speaking. Absolutely, it does. But it's not the only thing that matters. Other things that matter are the original intentions of the authors of the text, where the intentions, what they were trying to accomplish, depart from the meaning that they encoded in the text. That's another thing that matters. Another thing that matters is our historical practice. If we have been engaged in a certain type of practice that's been widespread and stable for a long time, our practices matter. Another thing that matters is certainly what comes out of the courts. Precedents are not just an exception to our constitutional order. They are things that matter. Also, various sorts of principles that you have heard of. Law students here will know principles of federalism, principles of separation of powers, principles of human dignity, the principle of equal dignity of the states. These are all different sorts of principles. These are not all encoded in the text. They are not our constitutional principles because they're the meaning of the text. They are our principles because over time, our legal order, principally our judges, but not only our judges, our members of Congress, our presidents, our populace, has taken up and committed ourselves to a variety of different principles. Like what your text said matters. That matters a whole lot. But what our historical practices over time have been matters a whole lot too. Principles of human dignity matter a whole lot too. Principles of federalism matter a whole lot too. So all of these things are the fundamental factors, not only the original meaning of the text. So we've got pluralism, not monism. And the second thing is we've got dynamism, not fixity. What type of dynamism? Organic dynamism. So you might ask, where do these principles come from? Well, I've already sort of told you. They come from the fact that we have, as a people, sort of committed ourselves to them. That doesn't mean every single one of us. There are 300 million of us. But a critical mass of us and our judges over time have committed ourselves to various sorts of principles. That's how all social phenomena arise. Why is it the case that when we greet friends and acquaintances, we shake hands? Well, because that's what people do. It could be different, and it has been different at different times and places, but here it is a true statement that norms of etiquette provide that you ought to shake hands. During the COVID pandemic, those changed a little bit, and that's not how you greeted people. Those things changed. Fashion. You're all wearing fashionable attire. But it wouldn't have been fashionable 200 years ago, and it's not going to be fashionable 50 years from now, because norms of fashion change over time. Word meanings, they change over time organically. People, irregardless. If you're a pedant and you used to hear people say the word irregardless, you either said to them or at least you thought to yourself, that's not a word. The word's regardless, not irregardless. But guess what? Last year, Merriam-Webster puts it in their dictionary. Why? Because now it's a word. It's a word now because enough people start using that word, makes it a word. Same thing with our principles. Everything changes organically over time. So the truth of our constitutional order is not fixity and monism at the fundamental level, that there's only one thing that matters, the meaning of the text. Rather, what matters is pluralism, a whole bunch of things, including, but not limited to, the meaning of the text. And the truth about those factors is their contents and their relative weights and importance and their particular contours all shift over time, sort of the way a river's banks changes over time. Slowly, organically. That's the way social phenomena changes. So how should we interpret our Constitution? We should interpret our Constitution the way actually judges were interpreting it for our entire history before modern originalism came around. And the way they interpreted was organic pluralism. They recognized that lots of things matter, that those things change organically over time, and the project of constitutional adjudication is to try to put these things together and to figure out where the balance is, the aggregate weighing of the various things that matter. Last thing I'll say is, in the same sort of way, roughly speaking, very generally speaking, the way you might make a decision in your life. Well, should I go to the University of Florida or should I go to Florida State? We all know, but that's an easy question. But should I go to law school or should I go and join the circus? Should I marry this person or should I go around the world? When you make these different decisions, there are lots of things that appeal to you. Well, I want to have stability and security, but I want to have lots of exciting experiences. I want to make money, but I want to have a lot of time with my kids. I want to do something interesting, but I want to do it with interesting folks as well, right? And you have all these considerations, and yet nonetheless, considerations that are built of different stuff, somehow aggregate to make a general decision about what all things considered you ought to do. That's the same way with constitutional law. These underlying plural considerations which slowly change their shape and their contours over time, aggregate to generate a decision. And the courts, when they're acting properly, should try to figure out what our principles are and should try to figure out what the aggregate weight of their import is. So I think the right account, I think the originalists really did us a service. Scalia really did us a great service by asking judges, really pleading with judges or shouting at judges to start asking themselves, hey, what is the law? What makes our rights what they are? That's helpful. But then once that question is asked, we should prize ourselves away from the simple answer, the simplistic answer, I think, which is, oh, well, the law is just the meaning of the text. Our lives are a lot more complicated than that. Our constitutional order is a lot more complicated than that. I welcome all of you to embrace, I think, a more realistic picture of our constitutional law, one of organic pluralism. Thanks very much for your time with me.
Okay, I'm going to step over here because you guys ended up sitting over here. So I'm going to stand over this a ways, closer, a little closer to you. First of all, I want to thank Mitch. I want to thank John for inviting me here to the University of Florida. Florida is one of the 3 law schools that gave me an offer to teach when I entered into law teaching. I didn't take the offer because I was from Chicago and my family's from Chicago and I hope to spend the rest of my life in Chicago. And so I took an offer from the Chicago-Kent College of Law instead of the University of Florida. For many years, I regretted that decision until I finally left the Chicago-Kent College of Law and went somewhere else. But anyway, it's always great to be at one of the schools that did give me an offer when I was entry level. Another reason is that lo and behold, I am now a resident of the state of Florida. I actually live on Siesta Key in Sarasota, which is paradise. I mean, even as compared to Gainesville, it's a nice place to be. So I'm very happy to be able to drive to the University of Florida to make this appearance instead of having to fly. So anyway, thank you, John, for inviting me here. Thank you, Mitch, for that wonderful presentation. Also, thank you for going first. Last time we did this at the Union League Club in Philadelphia, I went first, and so it was nice for him to go first this time. Before I say anything more, I would like to take a little poll and find out more about the audience. We've been told a little bit about the audience, so I'm going to ask how many are undergraduate, how many are law students, how many are other kind of graduate students, and how many are neither of those things. So how many undergraduates do we have here from the University of Florida? Thank you. How many law students do we have? Oh, my goodness. Okay, good. How many non-students do we have? I should say, how many faculty members do we have? Okay. Thank you. Now, how many none of those people do we have? Okay, great. Thanks. I always like to know who my audience is before I start talking. All right, so I'm going to talk a little bit about originalism, and I'm going to say also something about pluralism, which I'm glad that Mitch identified as his view because there are a bunch of different competing living constitutionalist views. Pluralism, I think, is the most popular one. and the most commonly held one, even by people who don't know they're pluralists. They actually are pluralists. And so I'm grateful to Mitch for having identified that as his view. But first I'm going to talk about what originalism is. And you'll find out that my definition of originalism is not quite the same as what Mitch attributes, rightly or wrongly, and I don't even know if it's wrong, to Justice Scalia, since I am not bound by whatever Justice Scalia might have believed about anything. There is some overlap between him and me. So I can define originalism in one sentence, believe it or not. Originalism is the view that the meaning of the Constitution should remain the same until it's properly changed by amendment. Let me just say that again, because it seems to befuddle so many people, not Mitch, but it seems to befuddle so many other people who are professors. Originalism is the meaning of the Constitution should remain the same until it's properly changed by amendment. Okay, now, originalism isn't just a single theory, and Mitch already alluded to this. Originalism is a family of theories. Original public meaning originalism is just one member of that family. I am an original public meaning originalist myself, so Mitch's commentary on original public meaning could apply to me, but it's a family of theories. There are variations on it, but because it's a family of theory, all the theories to be an originalist theory have to have two features in common. One is, and it's not the two features that Mitch said, one is the fixation thesis, which is something he did talk about, and the second is what's called the constraint principle. So what are these two principles? What are these two precepts? And monism is not part of this. I just want to say that monism is not a part of originalism as I understand it. So the fixation thesis is a descriptive claim about how language works. It's a claim that if you want to understand what language is and how it works, you will understand that that the meaning of a document, and in particular a constitution, is fixed at the time that it's enacted. So, for example, use a different example. So, for example, the meaning of the word domestic violence in Article 4 is fixed at the time it's enacted. So here's what Article 4 says. It's Article 4, Section 4. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. So basically, the United States guarantees to send assistance to any state to protect against domestic violence. Now, you all know that if that phrase domestic violence were used today, and you took a poll of what people thought domestic violence meant, it would be referring to spouse abuse or violence within a family violence. And polling has been done. That is the overwhelming public meaning of the word today. But it was not the public meaning of the word when Article 4 was passed. Domestic violence meant insurrection or riots in the streets. That's what domestic violence meant. Now, if you want to accurately read Article 4, you want to read it for what it means, would you use the meaning it had at the time it was enacted, violence in the streets, insurrection, or would you use the meaning it has evolved into? There's such a thing in linguistics called linguistic drift. It's what Mitch describes as how language has evolved over time. Well, the term domestic violence has evolved over time, and it no longer means what it meant before. But if you want to accurately interpret the meaning of the text of the Constitution, which meaning would you pick? Well, originalism claims, as a descriptive matter, that the way language works is that you would use the meaning it had at the time it was enacted. Just like if you picked up a letter that was written in the 15th century and it refers to the animal called deer, you would be mistakenly reading that letter if you attributed to the letter the meaning of the animal that we call deers, which are like Bambi and Bambi's mom. I actually don't know I should always memorize the name of that species. There's a specific species. But in the 15th century, deer referred to four-legged mammals. So, for example, it would include wild hogs. So if there was a statute that prohibited the hunting of deer in the king's forest, they wouldn't just be talking about Bambi, they would be talking about going after the king's wild hogs as well. Now, if you want to accurately interpret the letter that you find in the 15th century, Would you use today's meaning or would you use that meaning? So this is just a descriptive claim about how the final example I'll give you is the word dollars in the Seventh Amendment that guarantees Seventh Amendment or the Eighth? Which is the amendment that guarantees jury trials in suits greater than $20? I forgot. Huh? I was right the first time. Great. My guess was right. The Seventh Amendment. Now, what are the word dollar? Well, today, if you use the word dollar, what would you mean? You would open up your wallet and you would look at something that was called a Federal Reserve note that has dollar on it. Well, you can immediately see the problem. There were no Federal Reserve notes at the founding. So it couldn't have meant that. It didn't mean that. Federal Reserve notes came about in the 20th century. So what was a dollar? A dollar in the Constitution was a reference to a unit of a unit of silver that was called the Spanish silver dollar. That was a standard coin. In effect, there was no American dollar, by the way, when the Constitution was enacted. There was only the Spanish silver dollar, and eventually Americans coined their own dollar, which had the exact same silver content as the Spanish silver dollar. So if you want to understand what the word dollar means in the Seventh Amendment, you'd have to ask, well, what did the word dollar mean when it was enacted? Okay. Now, the fixation thesis is a descriptive claim about how language works. It can be disputed, like any other claim can be, but you'd have to have a theory, and people have other theories about how language works. You say, no, you have misunderstood the way language works. At least the language works when you're talking about writings, or the language works when talking about things like constitutions. You've misunderstood it. But that's the claim. Now, that's a descriptive claim. The second principle I talked about was the constraint principle. Now, the constraint principle is unlike the fixation thesis because the constraint principle is a normative claim, not a descriptive claim. And the constraint principle says that constitutional actors ought to conform their conduct to the meaning that is fixed in the written Constitution. Now, that's a normative claim. And normative claims have to be defended by normative reasons. And in fact, originalists have offered multiple normative arguments for why people today ought to follow the meaning that was fixed in the written Constitution until it's properly changed, as it has been 27 times, by written amendment. Because the Constitution that you ought to follow today, by the way, is not the Constitution of 1787 or 1789. It's not the Constitution of 1791. It's not the Constitution of 1868. It's the Constitution today as it has been amended. That is the Constitution that is in effect today. That is the Constitution that the normative claim is that constitutional actors ought to conform their conduct to the meaning of that Constitution as it was in effect at the time it was enacted. Now, what are some of the normative arguments on behalf of this? I can't make the normative case. I'm just identifying that this is a normative claim. But I'll give you the names of some of the arguments. There are arguments based on what you might call collective popular sovereignty, that the Constitution, this is the most popular argument that I think originalists put forward. It's most popular among originalists for why you ought to follow the original meaning of the Constitution. It happens to be one I don't agree with, but it is probably the most popular one. And that is that because the Constitution was ratified by the people represented the sovereign authority, and therefore their will is enacted in the text of the Constitution, and that's why people ought to follow the will of the sovereign, because you have a moral duty to follow the will of the sovereign, as enacted into this written Constitution. So that is one theory. There's another theory, another normative argument. And by the way, these normative arguments are not mutually exclusive. You could have multiple normative arguments. And in fact, that's a good thing, because the more normative reasons you have for doing something, the more likely it is that you ought to do that thing. Now, there's one the one I hold is kind of inconsistent with the one I've just mentioned, but I'll get to that last. The following are not inconsistent with the first. The first would be the rule of law. That, what is the Constitution? I hold a copy of the Constitution in my hand. What is the Constitution? This is going to sound a little bit like what Mitch is talking about, but maybe not exactly. One way to view this Constitution is that it is not the law that governs us. What this is the law that governs those who govern us. A written Constitution is a way for the people to subject their agents in government, for the masters, who are the people, to subject their servants in government to law by imposing upon them a written Constitution, because the people can't just order their servants around because they don't exist in that form. But once they've enacted this, then those who are their servants in government, their agents in government, need to follow the law that governs them. Those servants, part of them will be charged with making law that governs us. The law that governs us are going to be made by those people who are empowered by this Constitution. But wait, there's more. Because not only could that be the case, but it might very well be the case that anybody who attains power under this Constitution could be asked to swear an oath to follow the Constitution before they're given this power. And guess what? Everybody, every constitutional actor who gains power under this Constitution does take an oath to support this Constitution. To support what Constitution? The Constitution I hold in my hand. And what is the meaning of that Constitution? Is the meaning of that Constitution whatever those who take an oath to support it think it is? Want it to be? Define it as? Well, that would be like taking an oath to nothing. To take an oath to follow something, the something has to have a meaning independent of the view that you have. I was reminded of this quote because this is Alice in Wonderland. Room here, look behind you. There's a big Alice in Wonderland exhibit here. So I went out and I found this quote from Humpty Dumpty, which says, "When I use a word," Humpty Dumpty said in a rather scornful tone, "it means just what I choose it to mean, neither more nor less. The question is," said Alice, "whether you can make words mean so many different things." "The question is," said Humpty Dumpty, "which is to be the master. That's all." All right, so just, you're not supposed to agree with Humpty Dumpty here. I mean, I think many people do today agree with Humpty Dumpty that the words just mean what we want them to mean, but Lewis Carroll is trying to make the point that Humpty Dumpty's wrong about this, that words actually have a meaning, a fixed meaning in some sense, independently of whatever we might want them to mean. So we might want domestic violence in Article 4 to mean spouse abuse, but it doesn't mean spouse abuse. It actually means violence in the streets. And so the people who are to be bound by the Constitution, the people who get power only upon taking an oath to follow the Constitution, should no more be able to change the meaning of the law that binds them than we can change, without going through the amendment process, then we can change the meaning of the laws that they make to bind us without going through the legislative process. That's what we have to do. So if you get caught speeding in one of Florida's many speed trap zones, you can't say to the officer, "Well, you know, it was a living speed limit, officer, and nobody was there. I was totally alone. What I was doing was completely, I was sorry, that's not the speed limit. The speed limit is the posted limit." Okay, so so this is another normative argument, and it's based on the oath. And I think it's a fiction to think that we, the people, have consented to the Constitution, which is why I reject the first theory of democratic popular sovereignty, that it's ratified by we, the people. I think that's a fiction. But it is no fiction to say that each and every person who gets power under the Constitution takes an expressed oath. They swear either to God or they affirm, which you're allowed to do instead of swearing, that they will follow the Constitution. That's as much express consent to be bound as there ever is consent to be bound to anything. That's at least as much consent to be bound as when you rent a car and you sign the form at the ticket counter about the car rent. So at any rate, that's another normative argument. Another normative argument is separation of powers. The separation of powers argument says that this is about judges in particular, that if judges were to be able to update, reform, revise, modify, improve upon the meaning of the text of the Constitution, all of those things that living constitutionalists want judges to be able to do when they agree with the judges. They don't want them to do it when they don't agree with the judges. They would be stepping outside of their role of judges. They would be stepping into the role of a legislature. So that would be a violation of separation of powers. Let me just give you one more argument. It's the argument that I mean, I agree with all of those arguments, but the argument I also believe in is based on the justice of what the Constitution says. Because I think what makes a Constitution legitimate and therefore binding is the substance of what it says. So it must be, I'll just say, good enough to merit a duty of obedience in the citizenry when laws that are passed pursuant to the Constitution are imposed upon you. There must be something about the lawmaking process that creates enough goodness in the laws that are imposed upon us to create a presumption of obedience in the citizenry. So if you have a system of government defined in a written constitution that meets that substantive standard, it creates a reliable lawmaking process in which the laws that emerge from that process are necessary to protect the rights of others and not to violate your rights. If that constitution, if you have such a constitution, then you want that constitution to be preserved. You want to create a good constitution. And once you've created a good, if you have, there's a dispute about whether ours is good enough. Again, I don't have to debate the original one, which probably wasn't good enough. Or if it was good enough, it was only good enough for some people and not for other people. That's not the Constitution I have to defend. It's the Constitution we have today that I have to defend, that I would defend. If the Constitution is good enough, however we define that, then you want it to be locked in, which means you don't want its meaning to be changed unless it's properly changed by amendment. So those are the normative arguments for originalism. So that's what originalism is. Now I want to talk about monism, and then I'll talk about pluralism. Because I think originalism, properly understood, rejects monism just like Mitch does, and perhaps like Justice Scalia does. Maybe I'll tell a Justice Scalia story about how he came to my seminar one time. I think I'll do that. But let me just tell you what I'm getting at here. Many originalists, but not all, believe in a distinction called the interpretation-construction distinction. Not all originalists accept this distinction, but many do. I do. And been writing about it for a very long time. So what the interpretation-construction distinction stipulates is that there are two distinguishable activities that people who are engaged in constitutional adjudication or other forms of constitutional application engage in. The first is interpretation, and the second is construction. And by the way, the terminology, the labels don't matter. You could call them anything. You could call it interpretation 1, interpretation 2. But the accepted terminology that we've been utilizing for the last 20 years, which actually goes back at least to the 1830s, is distinguishing between one activity called interpretation and one activity called construction. Interpretation is the activity of identifying the communicative content of this document. Interpretation is the activity of figuring out, what is the fixed meaning of this document? What did domestic violence mean when it was written? You have to figure it out. Sometimes you might know, sometimes you might be surprised. It doesn't mean what you think it means. Identifying the original meaning of the text is the activity of constitutional interpretation. But here's the problem. This is why monism isn't right. The meaning of the Constitution is not enough to decide many, if not most, issues that arise in constitutional adjudication or in legal adjudication. And that's because the meaning of the Constitution is deliberately, in places, vague. There are clear cases in which it applies, and when cases are clear and it should apply, the constraint principle says, well, constitutional decision makers ought to be bound by the clear cases. So, for example, do the word arms in the Second Amendment refer to weapons that you have a right to, or did it refer to the limbs to which your hands are attached, also known as arms? Well, no, if you do a historical investigation, you will realize it refers to weapons, not arms. I think the full-blown investigation will talk about an individual right to keep and bear arms, not a collective right of states to have a militia, or an individual right that is conditioned upon service in a militia. I don't think it means any of those things. It just means individual right to keep and bear arms. If the meaning is identifiable, then constitutional actors today should be bound by it. But there are many words in the Constitution and passages of the Constitution that are deliberately general or abstract, and to some extent vague. Clear cases are in, clear cases are out, but there are a lot of cases in between that may not be clearly in or out. Because of that, in some sense, you could say the meaning of this runs out. It's not sufficient to decide every constitutional case today, any constitutional question today. So some other activity is necessary to apply the meaning that is here to the facts and circumstances of cases where it is not automatically governed by the clear meaning of the text. And that other activity we call constitutional construction. So how should you do constitutional construction? Now, this is something about which there has not been all that much theorizing, but I have put forward a theory of constitutional construction myself, which is what I call an originalist theory of constitutional construction. And that is the theory that when judges are, or any other constitutional actor, but I'm just sticking with judges for now, judges are attempting to apply the original meaning of the text to facts and circumstances that are not automatically governed by it. They ought to do so consistently with the original function, the original purpose, the original aim, the original object of those provisions. What was the problem for which these provisions were the solution? And to be faithful, and judges should be faithful. To be faithful to the meaning of the text, they ought to be faithful to the original purpose, the original object, the original end, not their own purposes, objects, or ends, but the purposes and objects or ends of those who adopted the Constitution, given that it's public meaning. That is what judges ought to do in the construction zone. But I won't say any more about that, only to identify this as a separate activity, which is important because it shows that originalists, I think, are not actually committed to monism, even though they sound like they are. So, you know who rejected the originalism construction distinction? Justice Scalia. Yes. 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 You're exactly right. That is 100% correct. And that is exactly the example I was going to give. So Justice Scalia, in his book on reading law, rejected the interpretation and construction distinction for the reason that you gave. It was trading on two words that are basically synonymous. Justice Scalia was historically wrong about this. The interpretation and construction distinction as a formal distinction goes back at least to the legal theorist Francis Lieber, a famous, at that time famous American legal theorist who was writing in the 1830s and expressly distinguished between interpretation and construction. And then Thomas Cooley, when he wrote his masterpiece treatise on the meaning of the 14th Amendment, consciously adopted Lieber's distinction between interpretation and construction. But I think if you go all the way back, even though the distinction, the terminology didn't exist, the two activities did exist. So I think he's historically wrong about that. But not only that, I just think he's wrong about the necessity of having to do it. So I'm going to tell you my Justice Scalia story. When his book came out, I teach a seminar at Georgetown called Recent Books on the Constitution. And I adopt one of my books and then 5 other books. And the 5 authors come and visit the class to discuss their books. It's 5 new books every year. I did this because this gets me to read 5 new books every year, and otherwise I'd be too lazy to read 5 new books every year. And not with the course of doing this for 15 or 16 years. I've read 86 books I probably would never read if I hadn't done this. Anyway, so I adopted Justice Scalia's book on reading law for my seminar, and I asked him if he would come to my seminar and discuss it like the other authors, and he said he would. So he came to my seminar. Now, my students were well aware, because they'd read my book first, that I believe in the interpretation and construction distinction, and I'm actually cited in those 2 pages, although he primarily opposes Larry Solar, just so you know, not me. But I actually am cited in passing there as having accepted this distinction that is a distinction. So I felt obligated at the beginning. He's there for 2 hours. The seminar runs 2 hours, so I felt obligated to put it to him at the beginning. So what's your view on the interpretation and construction distinction? I know the students would expect me to ask about it, and he gave the answer that he gave in the book, and that was that. So then I waited about an hour and a half as the class was going on. Maybe he was getting a little tired, he was a little bit relaxed. And then I said to him, at some point, it was relevant to whatever we were talking about. I didn't just do this gratuitously. And I said to him, but Justice Scalia, I said, you don't have anything against the courts adopting implementing rules to implement what's in the Constitution, do you? Implementing doctrines to implement it? And he goes, oh, no, of course, that's fine. And then we moved on. Well, all the students knew that the courts developing implementing doctrines is simply the courts engaging in constitutional construction. Most of what you learn in constitutional law, almost everything you learn in constitutional law, and this is partly what Mitch is talking about, almost everything you learn in constitutional law are doctrines that have been created by the courts. to implement what's in the Constitution. And that is mostly, and the name we attach to those doctrines is constitutional law, because that tends to be the law that governs the courts, the Supreme Court's law that governs the lower courts, these doctrines. And that is all in the realm of constitutional construction. So one of the cheap talking points that people make, originalists do this a lot, conservatives do this a lot, and that is, just where in the Constitution does it say that? Just where in the Constitution does it say, there should be strict scrutiny for this? Or just where in the Constitution does it say that? And the truth is that the Constitution says almost nothing about constitutional law, because those are all doctrines that have been devised as a way of implementing what the Constitution does say. So therefore, what is the relationship between this law that governs most of the courts, that the Supreme Court develops over time, and it evolves over time, just as Mitch described? These doctrines are constantly evolving. What is it what is the relationship between that and the original meaning, or the original meaning of the text? And that is simply that those doctrines, if they are to be good doctrines, ought to not contradict what the Constitution says, not undercut what the Constitution says, and be consistent with the original spirit of the Constitution, the original spirit of each of the clauses they're attempting to implement. Some constitutional doctrines, maybe most constitutional doctrines, fit this description, even though they're not written anywhere in the Constitution. But there are some that do not fit this description, and therefore they are to be opposed, as, in my view, as being inconsistent with the original meaning of the text, or not faithful to the original meaning of the text, and therefore bad doctrines that should be changed to bring constitutional law more in alignment with the law that governs those who govern us. Last thing I'll talk about is pluralism. As I already said, constitutional pluralism is probably the most popular, by default anyway, version of living constitutionalism. Living constitutionalism is a family of theories, and it's a family of theories that basically says the meaning of the Constitution should somehow evolve for some reason or another, and different living constitutionalists will have different reasons for it. There are multiple living constitutionalist theories. There is the moral readings theory of the Constitution, which is associated with my professor, Ronald Dworkin, who I had for jurisprudence. There is the common law Constitution theory that's associated with David Strauss at the University of Chicago, that basically says it is the law made by the Supreme Court, the common law made by the Supreme Court, that really is the Constitution, and the text is kind of how it got started, but then we leave it behind. That's another theory, and maybe I'm leaving one other theory out. But I think the most prevalent one in practice as well as in the classroom is pluralism. Pluralism, which is associated with a theorist named Philip Bobbitt, who was then at the University of Texas. He had a theory that he came out. When did Bobbitt write? 90s or the 80s?
81 was constitutional theory.
Okay, 81 and 90. So he said that there were different modalities of constitutional interpretation, which are the things that Mitch was listing out: text, intent. You could talk about history, historical practice, etc. And these are all different modalities of constitutional thought. Now, but text, and maybe the original meaning of the text, could be one of those modalities. Now, not every pluralist, I think, today would acknowledge that. Mitch did acknowledge that, but not everyone has to acknowledge that. But original meaning of the text could be one of the modalities. But what makes this a non-originalist theory is that the other modalities can trump or supersede or take priority over text. If the text was somehow prior and the highest value and none of the other modalities could supersede them, then it would be an originalist theory. But if all the other modalities, and under Bobbitt, these modalities are all of equal weight. I don't know, are all your modalities of equal weight? I mean, they needn't be, but generally speaking, but for Bobbitt they were. And so basically, as long as a decision maker can find one or two modalities that favors the outcome they want to reach, then they're good to go. That's according to that theory of pluralism. So the reason why that is objectionable, I think, is the reason why I think I already gave for the normative argument for originalism, because of issues of popular sovereignty, because of issues of separation of powers, because these other normative arguments for why constitutional actors ought to follow the original meaning of the text where its meaning applies, where its meaning is ascertainable and governs. That would be the argument for why allowing other modalities to supersede or trump text is wrong. But here, I just want to close by kind of maybe giving you one surprising report. And I think I'd be surprised if Mitch didn't agree with me about that. The leading pluralist opinion, the most famous pluralist opinion in the last year or two is the opinion in the Dobbs case, which is the abortion case. Because the Dobbs case, which reversed Planned Parenthood versus Casey, and also Roe versus Wade, Planned Parenthood versus Casey had already superseded Roe versus Wade, so that's the case that was really reversed in Dobbs. That was an opinion written by Justice Alito, and that was a difficult to completely understand opinion, difficult to completely characterize. It has elements of non-originalism in it, and it has some elements of originalism in it. So the elements of a non-originalism is it's based on history and tradition as it existed from the founding until today. That's not original public meaning. That is a modality of pluralism. That is living constitutionalism, that somehow the meaning of the Constitution evolves or that is settled by precedent, the tradition that may change over time. That's not originalism, and that's something that he relied upon. Also, he doesn't even opine on the original meaning of the due process of law, which is the clause he attempts to be interpreting. He says he's going to be governed solely by precedent, which causes him to have to look to history and tradition, precedent of Washington v. Glucksberg. So he's not, and then he says in a footnote he's going to punt on the issue of whether the Privileges or Immunities Clause of the 14th Amendment really is the right clause. So he isn't even going to tell us why the due process of law is consistent with the original meaning of the Constitution. In his concurring opinion, Justice Thomas says it's not. That the substantive due process doctrine that Justice Alito uses is inconsistent with the original meaning of the Due Process Clause. Justice Thomas claims, I think Justice Thomas is wrong about that claim, as I explain in my book on the 14th Amendment, but Justice Thomas's concurring opinion is an originalist opinion. Justice Alito's not. Finally, but there is an originalist element, and that is Justice Alito at least twice asked the question of, well, what were the abortion laws like in 1868? Or what was constitutional practice like in 1868? Well, if you're going to do history and tradition, 1868 doesn't really matter. It's not a special year. It's only a special year if you're trying to identify the original meaning of the 14th Amendment, which was enacted in 1868. So it has that originalist element too. But what I think that at the end of the day, what renders Justice Alito's opinion coherent is that it is a constitutionally pluralist opinion. What's true in 1868 is one of the factors that's going to go into his pluralist analysis of what the due process of law is, which is primarily governed by precedent, stare decisis, and our evolving tradition. And it's not really an originalist opinion. Now, I will say this: it is a conservative pluralist opinion. It's not a progressive pluralist opinion. Under progressive pluralism, you can take into account changing ethos, changing moralities, all those changing things. And under Justice Alito's conservative pluralist approach, it's all backward-looking. It's all looking in the rearview mirror, nothing forward-looking. But it's still pluralist. It's just a different theory of pluralism than the pluralism that progressives like Justice Kennedy used or other progressives in the Warren Court they used. So anyway, if you like your pluralism, you should like the Dobbs case, or at least you should like the way the Dobbs case was reasoned. But I myself would have preferred an originalist decision in Dobbs, and to a living constitutionalist decision, which is what I think Justice Alito gave us. And I think with that, we can go on.
Hello, is this not? Okay, good, still on. Well, thank you both so much. This was a really interesting set of talks, and so I was cheered to find certain points of agreement between both of you. And one of those points of agreement was that there is such a thing as constitutional law, that it's possible to get it right or wrong, right? That there is some content there beyond the preferences of the judge. And so I'm going to imagine for a second, as I often do, that I'm a Supreme Court justice. And I've listened to a pitch and so my job as a justice is to decide cases. And I'm only interested in interpreting the Constitution so that it will help me decide cases. And I've got to figure out which method am I going to follow, right? Am I going to follow originalism or am I going to follow pluralism, right? Those are the two options we're talking about here. And as a judge, I guess my first question before I can decide between those methods is, if my goal is to figure out what the law is, and we agree that the law is something, before I can decide a case, and I have to decide which method will best help me figure out what the law is, let me ask each of you, what is the law? That is to say, what is constitutional law? And I guess Professor Berman, since you went first, I'll ask you first, and then Professor Barnett.
Law is such a polysemous word. So when you say what is constitutional law, say more.
Say more? So, but I'm a justice. I can ask you. You have to answer my question, counsel.
You're a justice, but I'm not a litigator. That's one of the nice things about being an academic. You don't have to answer anyone's question.
So, I guess the point is this:
you mean what are the rules here?
I'm deciding cases. Mm-hmm. This is a purposive activity, right? And as part of that activity, I want to get the law right so that I can apply it properly to a case.
Yep.
But what I need to know, if I'm trying to figure out which method will help me get the law right, I need to know what the law is. That is, what is this thing that I'm trying to get right in the first place? I need to have some conception of that before I can choose my method. So what would each of you say constitutional law is?
Well, I think law is a complex artificial normative system. It's a system in use in political communities that generates norms, rights, duties, prohibitions, permissions, immunities, things like that. So we have a constitutional legal system. Like all legal systems, it's designed to output and sustain thoughts, obligations, duties, things like this, and to confer powers. Constitutional law is a particular legal system that has particular types of properties. It is given rise to by the constitutional document. It is supreme over other sorts of laws. So there are legal systems. There is a constitutional legal system. Constitutional law is the set of norms that are given rise to by the written Constitution. What are the norms? Well, I've told you in broad strokes what I think they are. So I think that the job of the judge then is to identify the principles inherent in our constitutional order. And that's in fact what appellate litigators do. Appellate litigators work through the materials and they say things like, well, there's a principle of federalism here. They often use the word principle. They don't always. They might say things like, well, the original meaning of the text was. When they say the original meaning of the text was X, then they are implicitly saying that one of the principles of our system right now is a principle that draws attention to the original meaning of the text and makes it legally relevant. So what I think the rule is, like, does a defendant have an indigent, this was the question raised in the case of Gideon versus Wainwright. This is the question that the judges had to answer. Does an indigent defendant have a right to the public provision of a defense counsel for them? To answer that question, I think we'd have to identify all of the principles that might bear upon the question, principles of practice, principles of of original meaning of the text, principles of maybe intent of the writers, principles of the dignity of the criminal defendant, whatever are the principles that are our principles in virtue of the fact that they have been taken up over time in our system, and then try to figure out how they bear upon that particular question. In hard cases, we are going to have a bunch of factors which bear upon the question, which often point in different directions. That's what makes it a hard case. Just like when you confront a question that you find to be hard, many you find to be easy because all of the relevant considerations are pointing in the same direction. But you feel that it's a hard question when you recognize that things that are relevant point in different directions. That's what makes a constitutional case hard when it's hard, is that the constitutionally relevant factors, relevant because they have been taken up over time in our practice, point in different directions. And then you have to use judgment to try to figure out how much they bear given the facts of the case. So it's hard to answer it in the abstract. What you would do really is you would do just what judges have been doing for centuries and what appellate litigators suggest they ought to do, because they identify lots of considerations and try to figure out what the balance of the factors is.
Well, I'm so glad you asked Mitch the question, that Mitch went first, because no academic I know of has spent more time thinking about and writing about what the law is than Mitch. He's certainly spent a lot more time thinking and writing about it than I have. So I have to answer this a little more naively, with a little bit less sophistication than he has. I would distinguish between lower courts and the Supreme Court in answering this question, or what the Constitution refers to as inferior courts and the Supreme Court. Now, the Supreme Court isn't just the name that we call the Supreme Court. It actually shows the relationship of that court to the other courts that are inferior to it. And so the inferior courts, I think, are inferior insofar as they must follow the dictates of the Supreme Court. And that requires some theory of stare decisis or precedent, in which the precedents that are established, however you identify them, and there are different theories of what it constitutes a precedent. The precedents that are established by the Supreme Court must be followed by the inferior courts, by the lower courts. And by and large, I believe they do attempt, the inferior courts by and large try to do this in good faith. There are certain amendments, for example, they don't like as many as other amendments. Many of them don't like the Second Amendment, for example, so they don't actually do that one in good faith all the time. But by and large, if it's not politicized, they tend to do it in good faith. The Supreme Court, however, I don't believe is ultimately bound by its prior decisions. No Supreme Court justice has ever considered him or herself bound by every prior decision. They all have a list of cases that they think should be reversed and that they would vote to reverse, or they have continuing to vote to reverse. So the doctrine of stare decisis is much more optional for the individual justices. And under those circumstances, I think what is law, because I've practiced law in the Supreme Court, I think what is law are the doctrines that the Supreme Court has adopted up until the day in which you argue. But I think those doctrines are subject to being modified or changed, and they ought to be modified or changed if they are inconsistent with the spirit or the letter of the text of the Constitution, which is the law that governs those who govern us. And so because I think the written Constitution is a higher law than the other law, I think that when there's a conflict, but only when there's a conflict, the higher law should govern. Then there's always a question of whether there is a conflict or not. That's an empirical question that can be disputed, whether there is a conflict or not. But I think if we're sure of it, then they basically should follow the higher law as opposed to the lower law. Now, there are, just last thing to say, because I don't want to talk any more about stare decisis. Don't ask a follow-up about stare decisis. Stare decisis can be very complicated, very fast. And so there are prudential reasons, there's epistemic reasons why judges ought to follow previous decisions, even if they personally think it may be inconsistent with the original meaning of the text. So I just want to throw out the fact that even for the Supreme Court, the issue of what they should do when faced with a potential conflict that they believe is a conflict is complicated. But with that caveat aside, I would stick with my naive and more superficial answer.
Thank you both. So stare decisis. I'll ask one more question, then open it up to the group. How much time do we have? We have time? Okay. Another point of convergence I found is that you both are in some sense pluralist. That is, you both have identified a series of factors beyond the original meaning of the text that courts can and should rely on in at least some cases to decide constitutional cases, right? Professor Berman thinks that these are the essence of constitutional interpretation, whereas Professor Barnett makes a distinction between interpretation and then construction, where you might see some factors. So I've made a list. It's probably not a complete list of the factors that each of you listed to rely upon. So Professor Berman mentioned original meaning, but also the intent of the framers, historical practices, precedents, principles, as factors that a court might rely upon in interpreting the Constitution. Professor Barnett, on the other hand, when talking about construction, talked about original function, purpose, aim, and faithfulness to original meaning. And again, I may not have gotten that list complete, but I think I'm sort of in the ballpark. My question to both of you would be, number one, why these factors? Like, why would you choose these factors and not some other factors in deciding what the Constitution means? Because you each have a somewhat different list. And then secondly, is there any hierarchical ordering of the factors? If you're engaging in this action of interpretation or construction, under your own theory of interpretation, would you give some weight, some sort of more weight to some factors than others in deciding the case? And Randy, I'll let you go first this time, and then.
Yeah, I disagree with the premise of the question. I don't think that I'm a pluralist. I think Mitch is a pluralist. So, and when I gave ends, objects, purposes, these are all synonyms for the same thing that we're looking at. So they're not alternative factors to go by. And they all should be superseded by the text if the text is identifiable, the meaning of the text is identifiable and is specific enough to actually be applied. 2 senators per state means 2 senators per state, no matter how many equality principles that text may violate. So I just think that the premise of the question is incorrect. And my understanding of pluralism, and now I'd be happy to be corrected by Mitch, is that there is no lexical priority to one particular modality, but he did say when I asked him about this during my talk that maybe there could be. So I'd be happy to hear from him more about what pluralism requires, because I'd be a student of his with respect to that.
Well, I love the idea that Randy would be my student. For those of you who don't know, Randy is a very significant constitutional person. I'm a very good father. Excellent parallel Parker. Okay, so here's the thing. There's a history here, and it's true that Philip Bobbitt is sort of the patron saint of pluralism. Randy got Philip basically right, but a little misleading. Philip's view is that there are 6 modalities of constitutional interpretation, and any constitutional proposition is true if it is validated by one of the modalities. So one modality is the original meaning of the text, let's say. If the original meaning of the text was P, then P is a true statement of constitutional law now. Another modality is the American ethos. If the American ethos says not P, then not P is also a true statement of constitutional law right now, albeit validated by a different modality. So what happens is you can have P and not P both true, Q and not Q both true. They're just true by reference to different modalities that make them true. Most people, including people who are non-originalist by sympathies, pluralist by sympathies, thought that's a complete mess. We need to know, is it the law that women have a constitutional right to terminate an unwanted pregnancy? Not, is it the law that they have this right relative to the text? And is it true that they have this right relative to our practice? And is it true that they have this right relative to whatever, right? We just want to know, do they have this constitutional right? And Philip said, no. There are just all these different modalities. They're all of equal status and what have you. Dick Fallon at Harvard came along and said, that's completely unacceptable. So we do need a hierarchy. It's like a decision tree. First answer this question. If this question, if the original meaning resolves it, end of story. If it doesn't resolve it, you go down to the next step in the decision tree. Now maybe you look to original intent. If that resolves it, end of story. And then you just keep going down in a stepwise fashion. I didn't think that was the question you asked me. I do not recognize that lexical hierarchy. I thought the question you asked me was, do I recognize that some have differential weights, just like reasons can have differential weights? And my answer to that is, yeah, principles can have different weights, but that doesn't mean that they're arrayed hierarchically, right? Weightedness and hierarchy are two different concepts here. So what happened was Dick Fallon comes along and says, if you've got a plurality of considerations, you do need to array them in a hierarchical, stepwise fashion. Most people were unpersuaded that he came up with the right hierarchy. Where does that come from? Does it exist out in the world? Are you trying to report what is already part of our practice? Or are you acting as an engineer and trying to create this new thing because you think it's going to enable us to run the system better? So I think that there are a bunch of factors, and there's more in an unstructured soup than in a hierarchical array. So I think that where do they come from? They come from our practice. That is, when a judge is trying to identify what our principles are, it's not something that they should figure out by staring up at the sky or consulting their navels. It's something that they would figure out by looking at the legal materials, looking at case law, looking at appellate briefs, looking at signing statements, look at what legally relevant actors have done over time. And we will see that those things change over time. In the religion context, I'm currently writing a paper on religion. Religious nation. Used to be Christian nation was a big principle of our order. You would see justices taking up the principle of we're a Christian nation in decisions. Well, over time, that has gone by the wayside, and we have basically abandoned that view because we are religiously pluralistic. So these things just change over time. You're trying to figure them out in the same way that when your kid comes to you and they're pierced or wearing pants that are all ripped up and you're an old and you think, well, I can't wear that. And your kid says, come on, Mom and Dad, it's fashionable now. That's what everyone's wearing. There is an answer to that question. And one could say, you know, I really hate that. I really wish you wouldn't wear it. But yes, it's true. I'm looking at the materials that I should look at to figure out what's fashionable. And you speak truly, child, that this is fashionable now, whether I like it or not. I do not see why it is impossible for a justice of good faith to be able to look at our legal materials and to be able to say that thus and such is or is not a principle of our order. Oftentimes it's going to be a hard question. But sometimes it's not that hard a question, and I don't see why it's impossible or we should think it's too hard for a justice to be able to answer that question, just like one can answer what are our fashion norms now without it being a question about what you personally like or dislike. So I think you look to see what has been taken up in our practice, and you try to figure out that way what our principles are.
Well, let me open this up to I don't know if I should bring the microphone around. I'll start.
Thank you so much for your time. It's very enjoyable. Please bear with me as I try to articulate my question adequately. In a televised discussion between Justices Breyer and Scalia around a decade ago, I think Justice Breyer listed out 6 different modalities that are used by judges to interpret different laws. I'm not sure how well they map on to the 6 modalities you mentioned, but he basically says that he attributes more weight to the last 2, and Justice Scalia attributes more weight to the first 4. But it is my understanding from what you're saying that originalists like to, instead of going through the different weights approach, they go through more of a sort of sequential Boolean investigation, whereby they ask yes or no questions and they stop when they say yes. What would be the harm of combining these two? Like starting with a yes or no question, is this governed specifically by the original meaning of the text? And then if not, assigning different weights to things. Because if I were to adopt the first reasoning, which is starting out with the weights, then through purposivism, I can theoretically go as high as I want on the abstraction ladder and assign as much value as I want to one of those modalities so as to favor the outcome which I want to be achieved.
Or for both of us?
I'm taking volunteers.
Okay. So we've got a whole bunch of considerations, a whole bunch of factors. And I'm putting forth a view in which they're not all hierarchically arrayed, like in a decision tree, but they're more sort of thrown out into our deliberative space, the more like the way reasons work. When you're making a hard decision, most of us do not follow a hierarchical pattern where we think this is the first consideration. If I'm choosing between these two jobs, I'm going to first decide which gives more money. Job A gives $3 more, therefore go for job A. That's not the way we generally make decisions based on a plurality of reasons, right? It's more like balancing and weighing rather than decision tree structure. So I think that there is a large part of that in our law. When you ask what would be the harm if, that sounds like a proposal for law reform. If we could coordinate ourselves, and if we could get the justices to follow a different decisional structure, where it's more hierarchical, wouldn't that be a good thing? Is that sort of the question? Am I understanding
Combine
correctly?
the two. Why not start with the premise that we will try to apply the text as faithfully to the text as possible, and if not, then we'd be left with 4 different factors to weigh.
Yeah. There could be a more complicated structure. First do this. If this resolves it, then go to plaintiff wins, or, resolves the case. If not, then you go on, and you could be another on-off switch, or it could put us straight now into a total balancing. And it could have any type of complex structure that an engineer could come up with. The problem is that nobody here has the power to impose that on the court. You might have a great idea in mind, just like Dick Fallon did when he said, this ought to be the order. First, go with the original meaning. And if that resolves it, end of story, and then go to these 4 things. Or you could say, have these 3 levels, and then go to these 4 things, or go to these 12 things. The problem is neither you nor Dick Fallon has the power to impose it upon the court. So what's going to happen, I think, always, is that it's sort of organic. It's sort of organic. We have a somewhat decentralized system. The court is not an it, it's a they. You've got 9 justices who have different views. And then what emerges over time is this complex interplay of the views of lots of different actors. When you have a decentralized system, it's just part of the nature of the thing that it's really hard to tightly regiment it, that you tend to get things that are messier. So I don't have a particular problem with your proposal. If we could get sufficient coordination so we have something that's more structured than the aggregative pluralistic picture I was putting forth to you, it's not that I have some strong objection to it. I was just trying to tell you what I think our setup is at this moment in time. And I think right now we do not have a high degree of hierarchical structure. And that's not surprising because getting hierarchical structure is more demanding of the underlying behaviors of the people than getting more like a soup, right? So I think we have something more like a soup, but with some elements of hierarchical decision tree structure. And I'm not opposing law reforms that would bring us to a more structured place. I'm just saying, if the main calling card, and I do think that this was the main point in Scalia's favor, that influenced a lot of scholars, Calabresi and Prakash and Paulson, and I can give you 10 more people, and Randy at one moment of his life before he more fully embraced the interpretation construction distinction, I thought. No, at no point. Where they thought that it is more structured. And I just don't think, so I think that his advantage was he could tell the rest of us, I know what the law is. I have a theory that tells us what the law is here and now, and it's the original public meaning of the text. That was false when he said it, and it is false today. That's my objection to it. But if you could become king or chief justice, and you could impose more structure so that it's less free-floating, that could be a huge contribution.
I became an originalist around 1999 after having read Lysander Spooner's great work, The Unconstitutionality of Slavery, which he wrote in 1845, because in it he put forward a theory of originalism that I hadn't seen anyone do and I thought would be workable and I might be able to make work. But I didn't actually have all the pieces in place and didn't publish anything until I read Keith Whittington's 2 books on interpretation and construction. It was Keith Whittington at Princeton who revived this distinction, and that was the final piece of the puzzle for me. So I really didn't become an originalist until I had the interpretation and construction distinction to explain what you do in the case of underdeterminacy of the text. The other thing I would just say is you can Google Randy Barnett and then Scalia's infidelity and find the article in which I gave the Taft lecture at University of Cincinnati Law School criticizing Justice Scalia's Taft lecture, which was called The Originalism, the Lesser Evil, in which I argued that because Justice Scalia gave himself 4 or 5 outs for when you don't follow original meaning, that meant that in operation he was actually not an originalist. Now, I wouldn't necessarily today, in hindsight, have said that Justice Scalia was not an originalist. I would have a reason for explaining why he was an originalist. He fits within the camp. Nevertheless, if you have 5 ways out that you can appeal to at your discretion, stare decisis, prudence, whatever it is, you're not really bound by original meaning, and Justice Scalia was not really bound by original meaning. And in his practice, he was not really bound by original meaning, and neither is Justice Alito, even though he calls himself an originalist.
Is this thing on? All right, cool. Hi, thank you very much for coming. So I'd like to preface this by saying I have a fantastic constitutional law professor, and I'm not just saying that because she is 3 feet away from me.
But that doesn't hurt.
However, I am terrified I'm going to fail this class because, for the life of me, I cannot take the Supreme Court seriously. Personally, I think they do whatever they want, whenever they want to. And I would just like to know, how could organic pluralism and or originalism help me take the Supreme Court more seriously so I do not fail?
Well, I would not necessarily admonish you to take the Supreme Court more seriously. The first sentence of my first book on the Constitution, called Restoring the Lost Constitution, says if the justices had been doing their job, this book would not need to be written, because it was all about what they were doing wrong and how they'd been doing wrong things for a long time, both descriptively and normatively. So I don't think you're under any duty, and I'm sure your professor is not going to require any pledge of fidelity to the Supreme Court to do well on the exam. So all I would say is that I think everyone ought to approach the Constitution seriously. They ought to think about it hard. They ought to decide how they think the Constitution ought to be interpreted. Because remember, normative claim is part of originalism, I stress. It's not just descriptive. And then you can assess the performance of the Supreme Court according to either its outcomes, and whether you think its outcomes could be justified under original meaning, even though they weren't justified that way, or its reasoning. So, for example, take the Dobbs case. You might argue that even though the Dobbs case is not reasoned in an originalist way, its outcome is far more consistent with the original meaning of the text than what the dissent was going to do in Dobbs, or what Roe or what Casey did. And if you take that view, you could applaud the outcome of the Dobbs case, even though you condemn or you are disappointed in the fact that they did not decide to do an original. I'll give you a better example for me, and that is the McDonald case in the city of Chicago versus McDonald, which applied the right to keep and bear arms, the individual right to keep and bear arms, to the states. I think that is an easy, unbelievably easy case to be done under the Privileges or Immunities Clause of the 14th Amendment that most all scholars of the 14th Amendment would agree are easy, regardless of their ideology or their politics. And yet Justice Alito, once again, and by the way, I like Justice Alito personally very much, and I respect Justice Alito. I especially respect his intelligence. I think, but I'm going to be discritical again. In McDonald, he absolutely refused to consider the original meaning of the Privilege and Immunities Clause. He once again, just like he did in Dobbs, decided his case on the basis of a substantive due process theory based on stare decisis and not on original meaning. That was wrong. And I just should add as a footnote here that during oral argument, when Alan Gura, who's a friend of mine, stood up and argued the McDonald case and argued for the original meaning of the Privilege and Immunities Clause, he was ridiculed from the bench by Justice Scalia. Go listen to the oral argument in McDonald. If you haven't listened to it on oyes.org, go listen to the oral argument and listen to how caustic and dismissive Justice Scalia was towards a litigant, a lawyer in front of him who was respectfully urging the court to adopt the original meaning of the 14th Amendment. It was conduct unbecoming a justice, I think, and conduct especially unbecoming a justice who purports to be an originalist judge.
I feel your pain. I really do. I find it hard to have respect for this court. I find it's hard to have respect for the individual justices who make up this court. That's the justices whose political leanings are more in line with mine and those who aren't. I think that the originalists are arrogant in thinking that they've got the insight to truth. I think they don't have the insight into truth. I think they're just substantively very mistaken. But even if they were right, it's conduct unbecoming over and over to accuse those their peers who have different views of making things up and so I think that's really unattractive. People might like some of their results more. They don't have a theory of law at all, and I don't think they even care. So Justice Breyer was the closest thing to someone on the left of center side who had a theory of constitutional interpretation. It was nonsense. It was just, make good decisions. Then you've got Kagan, who just says things like, we're all textualists now, and it's not true, never has been. You've got Jackson, who now says progressive originalism, which I think is conceptually confused. Not because I think originalism is necessarily conservative, but because it's necessarily not supposed to be either progressive or conservative. It's a different sort of inquiry. So I just think, a pox on all their houses, frankly. And it's hard to be a con law professor in that environment. But I will say that my colleague, Eric Siegel, who is also, like me, a non-originalist, has the view that there's no law, that it's just a law-free zone and everyone is making it all up. And I guess what I think is that lots of the justices really just are making it up. And my project is to try to speak to an imagined justice who is trying not to make it up. My thought is, it may be true that all of our justices on both sides of the aisle and across the political spectrum are really exercising will, not judgment, in the terms of Hamilton, the founder of your center. He didn't? In Hamilton in Federalist 79, distinguishing 78 between will and judgment, right? I think most of our justices are exercising will, not judgment. But I do think that there is law there to be discovered in this very complex way if someone wanted to exercise judgment. There is something for judgment to latch onto. And that's what I'm trying to put forth. And I think that if we had the next coming of the second Justice Harlan, for example, or maybe a Justice Souter, those are justices who I think really were trying to figure things out. I think it is possible to try to figure things out, and I think we constitutional scholars then could do a better job of trying to give them accounts that would enable them to do a better job of exercising judgment if only they were disposed to do so.
I know we're nearly out of time, but I do want to say something more positive about the justices than I myself said a minute ago. One of the things that they're commonly accused of, and Eric Siegel is a person who does this, and that is they're accused of simply reaching either the political result they like or the result of the political party to which they're affiliated. And that's what they do, and that's why they're not to be respected, and that's why it's not a court. And I don't think that's correct. I am a legal realist when it comes to the Supreme Court, because I don't think they are necessarily bound by the text of the Constitution. They don't act as though they're bound by the text of the Constitution, even though I think they should be. But I really do think, that they are committed to their vision of constitutional principles, not results, but principles. Now, sometimes there are cases which I think results matter more than other things, but by and large it's principle. And my Exhibit A about this is going to be the Raich case that I brought before the Supreme Court and I argued in front of the Supreme Court. And that is the medical marijuana case out of California. And in that case, I got 3 votes by from Chief Justice Rehnquist, Justice O'Connor, and Justice Thomas on behalf of medical marijuana coming out of California, and the Ninth Circuit. And I know that those justices did not agree with my client on policy grounds. And Justice O'Connor said in her dissenting opinion that she did not agree with my client on this. But they had a vision of the Constitution of federalism that led them to vote for me and my client. Not me, but my client. On the other hand, you would think that I've went up to the Supreme Court that I would have had a shot coming out of the Ninth Circuit and defending medical marijuana. I might have had a shot at any of the progressive justices on the court at that time, Justice Stevens or Justice Ginsburg, Justice Breyer. I never had a shot with them. There was no, I mean, we like to convince ourselves as litigators you do have a shot at them because they're sympathetic, they're sympathetic with the cause. They're sympathetic with my client. I had a very sympathetic client, two clients. I had two clients, one who was, threatened with death if she didn't use it. The other had excruciating pain if she didn't use it. I would have had all the sympathy going for me. It came out of the Ninth Circuit. A liberal panel ruled for me below. Did I ever have a shot with them? No. And why is that? Because I think they adhered to their principled commitment to broad federal power over their compassion for the sick and the dying. And at some level, you kind of have to admire that. So that is what I would say is an example of constitutional principle in action. I think most of them, most of the time, are motivated by constitutional principle. I only wish that a majority of them, their principles was to follow the original meaning of the text, which we don't have a majority of justices who are prepared to do that yet. And that's my vision. That's what I do as an advocate, is I urge the justices to follow the original meaning of the text, regardless of where it may lead them politically. And, hope, and we have made progress along those lines, but we are far from, we haven't got a majority, and until you have a majority, you're not going to win.
Thank you. I think we had a couple people down here. I don't know if there's anyone.
I have one more.
I'm sorry, sorry.
Thank you both for coming. I have a simple question. You have some history with it, I know, but how would you define interstate commerce?
It's commerce that takes place between more states than one. Commerce that takes place between one state and another.
Would you, I guess you would not.
You want to decide interstate or commerce? Commerce is the movement of people or things or goods, whatever, from one place to another. And interstate commerce is when that activity takes place between one case or another.
Would you agree that the aggregate principle is in
The
line with?
aggregation principle of Wickard versus Filburn? I think that's a bad implementing doctrine. First of all, it is a modification of the substantial effects doctrine, which was established in Darby. This is inside baseball. For those of you, don't worry about this if you're not law students. I think the substantial effects principle is a bad implementing doctrine because it is not faithful to the original meaning of the text. And the aggregation principle, which is a modification or a refinement of the substantial effects doctrine, is also a bad principle. So those are bad implementing doctrines, and therefore they should be unconstitutional.
Only if he wants me to.
You can, but...
Thanks, pal. Couple quick things. Interpretation, construction distinction. Randy and I have argued about this before, although I don't know that he's ever fully cottoned on to my view here. He probably has, because he's a smart guy and he just disagrees with it. But I think that there is a distinction to be made here. I would conceive of constitutional interpretation as the activity of trying to figure out what the law is, not the activity of trying to figure out the communicative content of the text. And then what he calls construction, I have no problem with construction. I think that's the crafting of implementing doctrines. So I agree with him there. But where he thinks that there are two steps, interpretation is the activity of trying to figure out the meaning. He used the word meaning a lot, and that's not accidental. And you might have noticed when I was up there, I never used the word meaning when I was referring to the thing we're ultimately looking for. We're looking for things like norms, rights, prohibitions, permissions, duties, not meaning. Meaning is a communicative concept. So he thinks that there are two steps, the activity of trying to figure out the meaning and then the crafting of implementing doctrines.
What would you have me call?
I think there are three steps.
What would you have me call the first step?
I would call that maybe linguistic interpretation and contrast that with legal interpretation. So I don't care what you call them. You can call them interpretation 1, interpretation 2, interpretation 3. But the important thing is that there are 3 steps. There's the activity of trying to figure out the meaning. There's the activity of trying to figure out the existing law. Those are the same steps for people who believe that the law is fully constituted by the meaning, but not for people who think otherwise. And then there's the step of crafting, implementing doctrine. So I just don't think that interpretation has to be understood as interpreting the meaning of the text. I think it's the activity of trying to figure out what the law is. And that still leaves open the idea there's a second step of crafting, implementing doctrines. I think that the language, of course, is not interstate commerce. It's commerce among the states. And there's a question of what commerce is. What does that mean? I think it may well be, Randy has argued, and I'm not an historian, but I've read his stuff on it. It seems pretty persuasive, that commerce originally was just the buying and selling, and it was distinguished from things like manufacturing and farming in the 18th century mind. I don't think that's true today. So I think that the meaning of the term commerce has changed in a way that the law of what's a permissible regulation of commerce among the states also has changed. And I think it's important to understand that organic change in the contours of the extension of the word commerce is a different type of historical linguistic change than the one that's represented by the domestic violence example. That is an example of opportunistic accidental change. Gosh, it's just sort of surprising that a term domestic violence, which used to mean rebellion, now is applied to spousal abuse. It's sort of accidental. Whereas changes in the meaning of the word commerce to be just buying and selling versus other sorts of economic activities that relate to buying and selling is an organic change in the word that accordion-like over time. And I don't think the fact that we all agree that we shouldn't give this weird meaning to domestic violence establishes that we shouldn't as well give a different meaning to the term commerce that changes organically. I'm not saying that we must, but I just want to say that the domestic violence example, I think, doesn't cut as forcefully and as far as the wielders of that example often think.
The Supreme Court has never changed the meaning of the word commerce. It never acknowledged a change in the meaning of the word commerce, with one exception, and that is a 1946 case in which they included insurance, seeming maybe in a very confusing opinion. They may have said insurance is a form of commerce, which it wasn't. But other than that exception, they've never changed the meaning of commerce. The substantial effects doctrine and the aggregation principle, Wickard versus Philward, were all based on the necessary and proper clause. And those in those decisions itself, it says Congress can reach activities, and they cited McCulloch versus Maryland as authority, which signals it was a necessary and proper clause case, though they be not commerce, is how the court referred to it. They didn't change the meaning of the word commerce. They extended Congress's power to implement the commerce power by means of the necessary and proper clause to reach all kinds of activities that are not themselves commerce. I agree with some of that. I think in order to regulate interstate commerce, you might have to regulate activities themselves that are not commerce, like blowing up a bridge. Blowing up a bridge is not commerce, but the bridge is an instrumentality of commerce, and to protect bridges in the course of protecting interstate commerce, you might want to make it a crime to blow up a bridge or a port, which is another instrumentality of interstate commerce. So I agree with that. But I just want to say that there has been virtually no linguistic drift at the court. Now, there may have well been linguistic drift after pounding into the head of law students for the last 30, 40, 50 years that the meaning of the word commerce is broader than what it was originally intended to be or how it was originally used. That might have changed ordinary discourse, but that's just a result of indoctrination, not because the court itself has done that work not because the law, as the court has enunciated, has changed.
First, thank you for the talk, or talks. I'm not sure whether to pluralize it. I thought it or they were excellent. So I had a couple of questions for each of you, but one of my questions for Professor Berman was preempted by the foregoing Q&A, so to balance it out, I'll give you a toss-up, and you can choose which one you want to answer. Professor Barnett. So for you, I was going to ask I'd be interested in hearing anything you have to say about Keith Whittington's theory of popular sovereignty. I think it's chapter 4 or chapter 5 of his book on constitutional interpretation. And I'm curious, the other question is, I'm curious why you don't like the popular sovereignty argument for the constraint principle. I think you said the one you prefer is that if there is something of sufficient substantive goodness in the Constitution, then we should want to preserve that. And I would venture that the prime factor in that regard is the securing of democratic sovereignty or popular sovereignty. So that's what I would see as the reason to preserve it. I'm curious as to your views there. Professor Berman, so you gave a number of reasons that you thought we should be skeptical of originalism, including a few that I would group together under the label of, to use the Hegelian term, changing Sittlichkeit. So changing commitment to various principles, practices, etc. And my question there is, if the will of the people does sufficiently change over time to warrant these sorts of changes in constitutional interpretation, why not just rely on the mechanisms for constitutional amendment, which are already specified by the Constitution, and which would preserve the democratic sovereignty?
I'll go first. I wrote a book about this called Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. And in that book, I identify two competing theories of popular sovereignty. Years ago, I rejected popular sovereignty in my first book altogether, but now I think there are actually two competing versions. One is the collective vision of popular sovereignty, which is, I think, what you're calling democratic property sovereignty. It was really associated with the rise of the Democratic Party in the 1830s, although it pre-existed it. It goes back farther than that. But it was, in my book, I argued that vision was repudiated, actually, when they adopted the Constitution, because the Constitution is anti-democratic in so many different ways, for which it's criticized today. I mean, the Senate is criticized for being anti-democratic because it's not apportioned fairly. The Electoral College is likewise considered to be anti-democratic because it could yield a result that's different than the popular national popular vote. There's all these different veto gates that are not democratic, and therefore they're wrong, according to this democratic popular sovereignty argument. But in my book, I identify another conception of popular sovereignty that I think was affirmed by the Constitution, and that is the notion of individual popular sovereignty, which is measured by the individual rights of we the people, each and every one of us. And therefore, under this version of popular sovereignty, which I kind of was referring to obliquely in my original talk, the merits of a constitution is how well does it protect the background rights of we the people. Then it is consistent with the popular sovereignty of we the people, all of us, because the government is not us. The government is there to secure the pre-existing rights of we the people. And so popular sovereignty of us, as all of us, would dictate that they need to follow the law that governs them if the law that governs them is the substance of what that law is sufficiently good enough to provide assurances that they are going to protect our rights, that our rights will be protected if they follow the law that is there to govern them. So I would just urge you to take a look at that book, in which I do all of this at much greater length than I can do it here.
Great questions, thank you. Very briefly on your question to Randy, I'll just say that I think popular sovereignty is a big principle of our system, and one that our justices are not taking seriously enough. It is one of the big non-textual, by which I mean there are textual bases for it. There are links to it. It connects to the constitutional text. But it's not the case that the communicative content of any particular proposition says something like federalism. We've got the 10th Amendment, which is gestures in that direction. We've got things that gesture toward distribution, non-concentration of powers, and popular sovereignty. But it's not the case that it's the communicative content of a provision. And nonetheless, our justices have taken non-concentration of power and federalism very seriously. And what they haven't taken as seriously as they ought to, in my view, is principles of popular sovereignty, of hugely pressing concern right now. I'll just flag for you. Look at the Shuffalo opinion, for example. If you know that that's on the faithful electors or faithless electors case. I can give you lots of examples afterwards of cases where you would expect to see the courts speaking to the principle of popular sovereignty, and it's conspicuous by its absence. And I think that's a huge problem right now politically. Now you ask, why not just have all changes occur through the Article 5 process? Well, because it doesn't really work. So I'm a positivist. I don't know what you know about legal philosophy, but I can tell just by your citing chapter 4 in Whittington's 1999 book, you didn't come to this just off the street, right? So my basic view is I'm a positivist about law. I think our law is ultimately determined by what we recognize it to be in some sort of sense. So I think it's the case that there are a lot of pressures. When you have a system that's hard to formally amend, it's not surprising that the decision makers in our system, basically the justices of the Supreme Court, end up becoming pluralist. You can imagine this occurring over time. At time T1, the day the system is created, everyone is a monist, original public meaning person. They say the law is just the meaning of the text. And then what happens over time is they confront cases in which it just feels intolerable to them to reach a verdict, a judgment, which comports just with the original public meaning of the text. They just feel that can't be right, either for political reasons, moral reasons, feeling of what the public would accept. So it leads to pluralism over time. If you have a system in which the text can be formally amended relatively easily and quickly, you tend to see the system develop in a more monistic way where we're paying more attention to the text of the Constitution. You see that in sports. In sports, the formal rules can be amended very reliably in the off-season. It happens all the time. Not surprising then that you get the interpreters being more textualist. We, in the U.S. Constitution, is at the the farthest extreme away from the NFL rulebook. Their formal amendment is so difficult that there's sort of a hydraulic pressure upon the decision makers to be pluralist and to take other things into account because the decisions that they would reach if they were monistically public meaning are just intolerable. So it's not surprising what Randy said earlier, that we've never had a majority of justices who are just monistic originalists, because even when they give lip service to that, they cannot live that way because it leads to results that even they can't stomach. So there wouldn't be anything terrible with just leaving it to the amendment process if it were a process that could be amended more easily.
So, very brief follow-up.
Actually, I just want to follow up, and I'll take priority over your follow-up. I just want to suggest, since Mitch had identified as a positivist, I identify as a natural rights person. So I think first come rights and then comes government. And I'm also a natural law person as well. So I think that, but I also don't deny the existence of the positive law. I think the positive law is the positive law. And then the question for me is whether the positive law that's imposed on we the people is binding in conscience on us, which means we have a prima facie moral duty to obey or not. And that will depend on how the positive law corresponds to the background principles of natural rights as well as some principles of the natural law. So just to identify where we differ, that's my view.